Welcome to Law and Justice. I'm Jane Mulcahy. This is a special series on the topic of how to talk policy and influence people. And today I'm speaking to an old boss of mine, Ray Byrne from the Law Reform Commission. And I'm really pleased that Ray took time to speak to me from his car in the middle of nowhere during COVID-19. Hi, Ray, how are you?
Hi, Jane. Thanks very much for the invitation.
Ray, sorry. As I mentioned, you're working at the Law Reform Commission. Can you tell me a bit about yourself first and a little bit about your professional background, please, Ray?
Okay, so right now, parent, spouse, proud Wexfordian as well, and speaking from Wexford, doing lots of distance and remote working at the moment. And I suppose, how did I end up in the Law Reform Commission? And what a fantastic privilege it is to be working in the Commission, because we do get to influence a lot of change, which to me is quite important. And I suppose my background, having done law then, was to do a little bit of practice at the bar, but I was also very interested in teaching. So I was lucky enough to get a job in DCU. And really enjoyed that, because again, I really like talking about law, as you probably know. And then also that really kind of got me into research, and certainly that was something that really interested me. And so I suppose from doing that research and a little bit of writing, then I also got an interest in reform of the law. And so again, incredibly lucky to be asked to become initially Director of Research in the Commission back in 2003. And then, really enjoying that job. And then having served under two great full-time commissioners, I got the opportunity to apply for that role. And so that's what I've been doing for the last 4 years now as full-time commissioner in the Commission. But it's very much a collegiate body where you have 5 commissioners supported by a terrific research team headed by Director of Research, who at the moment is Rebecca Cohen, formerly of the DPP's office. And then we've got a great team of researchers, many of whom are on fixed-term contracts, but just in the last couple of years now, we've managed to get a couple of researchers on a full-time basis, which is a terrific addition to our team as well. And then we've got a team working on a different side of research, which is on accessibility of legislation. And I might talk about that a little bit later. So that's kind of my short history of how I've got here, Jane.
Yeah, thanks, Ray. So, I mean, I worked at the Law Reform Commission for a couple of years myself as a legal researcher when you were the Director of Research, and had a great time there. It was really interesting. I worked on the law of homicide and murder and manslaughter.
Yes.
Can you tell people, for those who do not really know what the Law Reform Commission is it a state body? Is it independent? What is its actual function and mandate, Ray?
Yeah, okay. So it's been going since 1975. So there's the Law Reform Commission Act 1975, and our mandate is to do research on the law, identify are there problems and issues, and to make proposals for reform of the law. And written into the legislation is the idea of simplifying, if we can, the law, modernizing the law, if we can, and codifying the law, if we can. So all of that is part and parcel very much of what our role is. Our job is to try and make the law basically more accessible, so far as we can actually achieve that. A bit easier said than done, but that's what we try to do. We really try our best to make sure that the work that we do when we produce something, that we actually make it as readable, as accessible as we can for anybody who is interested in law reform. But we are an advisory body. So we are a statutory body, we're a state body, we're funded by the government, but we also have very much independence in terms of how we go about our research work. and how we formulate proposals for reform. And I suppose we do that by consulting a lot with interested people, and the main way that we actually kind of decide, well, what areas of the law are we going to look at, because law is a big area to look at. So what we do is we consult every 3 to 5 years with the public, go around the country asking people what their views are, and we're usually hosted by the university law schools, and they gather in people from their area, and so we have that opportunity to get to hear from people. So it's not just Dublin centric. We try very much to make sure that we hear voices from around the country when we're collecting together, in a sense, a set of projects that we then put into a draft program of projects, or a program of law reform, and under our legislation we then present that to the government, and the government must formally, under the Law Reform Commission Act, approve it. And they've also taken the view over the last number of programs that we've developed, that they send a draft program to the Oireachtas Justice Committee, and they get an opportunity as well, if they want to bring us in, to ask us about, you know, why have you chosen these particular topics. And while the formalities of it are that we have to have that programme approved by government, so that has to go to cabinet, and there has to be a formal cabinet decision to say yes or no. But certainly in my experience, in the time that I've been there, what happens is that we're kind of, I suppose, careful about what we would include. We have a set of criteria that we use to determine what should be included. So there are certain things that we just kind of feel, as a group of lawyers, but with the benefit of a huge amount of input from NGOs, non-law people, people who can actually tell us what's going on, sometimes in what might be described as the real world.
Right.
We try to come out of our ivory tower, and we try to be as real and as applied as we can, but we get the benefit of all of that. But at the same time, the 5 commissioners are lawyers, and so we have a certain amount of expertise in that area. So we try to put together a set of projects and topics that we think we can do. And my experience then is that provided they are topics that I suppose we are competent to deal with, then the government tends to say, well, okay, you make the call about whether you think those are really things that are relevant. So we try and present them as relevant projects for contemporary society and the needs of reform in law. And the government will, in a sense, take the view that it's not for them to say, well, there are a lot of things that they would like to have reform on. So it tends to be a situation where the Commission actually does have, in practice, quite a lot of independence in terms of the content of those proposals. And often, when you get into some of those proposals and start doing the work on them, it might only become apparent to policymakers and government and politicians that these are really important issues that do need to be addressed. So they do tend to give us that, if you like, margin of appreciation to say, well, okay, if those are the topics that you've consulted on and that people have said need to be looked at, they will allow us, in a sense, even though they could say, or we don't like this topic or that topic or the other topic, or we don't see the relevance of it. But essentially, any draft programs that we put together tend to be approved without any changes or deletions.
But Ray, I suppose because you're oriented towards law reform, it's not essentially designed to be an academic exercise. So when you're choosing topics, I presume it's because you guys feel that there's something going on here. Either it's too ancient or too confused, or it would benefit, you know, from modernization or simplification. I remember before I was there, you'd looked at sentencing. You may have looked at it now again since because movement or traction can be slow on these things, or sexual offences. And then the Courts Acts you were looking at around the same time. land law reform. I mean, some of our laws were ancient, truly ancient, and rather archaic in how they were drafted. And I remember
Yes.
sitting in with you as a young researcher, and you talking about plain English and the benefits of boiling things down so that the man on the street, you know, who can read and has adequate comprehension, or the woman, could have a sense of what are we trying to get at with this. So are there areas that you're looking at now, for instance, that, you know, had been neglected by the Oireachtas for some time that you thought, you know, we need to look at this? Can you give me some examples?
Yeah, well, I think in a way, the whole point of having a law reform commission is that it is there to go out and you know, it's not just us sitting around a table and kind of saying, well, what would my lovely pet project on law reform look like? So we take advice from everybody. And as I say, that's an incredibly important part of our work, public consultation and listening to what people are saying. And that does sometimes mean going out and asking people, what are the areas that need to be looked at? So, for example, when we went out consulting, and that included going to places like Cork, for example.
Amazing. Thanks,
Yes.
Ray.
Yes. So that was an incredibly useful exercise, because we went and we talked to people in Cork, in Limerick, Galway, Dundalk. And we did talk to some people in Dublin as well. But the great thing about that is that you get a sense of what are the areas that need to be looked at. And as you say, there are some areas that actually kind of tend to come back again and again, because you look at it at one particular time. So the Commission, as you mentioned, looked at the law of sexual offences back in the 1980s, made very important recommendations that were included in the Rape Amendment Act of 1990. And we've been looking at various aspects of that again over time, so that in the last few years, we've looked at issues around capacity to consent and decision-making in that kind of a context. And so moving very much from what might have been regarded as, I think, a very much paternalistic law on capacity and decision-making in the sexual context to an empowerment with appropriate protection. But I think very much moving towards a rights-based approach, taking account of the Convention on the Rights of Persons with Disabilities and using that as a reference point to say, this is an area that needs to be reformed. And that reform did get some traction then in the Sexual Offences Act 2017. And then very recently, and I should add that in addition to doing some programs, projects in programs of law reform, we can be asked by the Attorney General of the day to examine discrete areas and look at those. And we were asked by the former Attorney, Maura Whelan, to look at the area of knowledge or belief in the context specifically of rape law. And that was being debated as the 2017 Sexual Offences Act was going through, but it was felt because it was raised kind of coming towards the end of that Oireachtas debate, that it might be preferable to just leave that over for further consideration. So we did a report on that and completed our work on that last year, and that made recommendations to say that the currently really primarily subjective test, which means that somebody can be acquitted on the basis that they may subjectively but unreasonably believe that a woman was consenting. And we said that that was not an appropriate test to continue with, and that we should move towards a primarily objective, reasonable belief test where the issue of consent could be more front and center in the analysis of whether somebody had committed the offence of rape. So we made those recommendations last year, and they certainly seem to be welcomed in general terms. Now, they haven't been transformed into implementing legislation yet, but certainly we would hope that the way in which they were welcomed indicates that there might be some positive movement on that. So that's one example of where, in the law of sexual offences, the Commission over many years has done a lot of work in that area, and believe it or not, now we are in our new program of law reform that was published last year. We are going to look at the whole area of sexual offences law, and with a review to looking at some areas that might still need to be reformed, but also bringing together all of the legislation in this area. And indeed, there are some common law aspects, non-statutory aspects of sexual offences law. So we really feel that at this stage, it's not good enough to have the laws scattered throughout loads and loads of different pieces of legislation, some of which go back to 1861. And so one of our purposes there, consistent with our statutory remit, would be to consolidate and, in a sense, codifying, bringing together all of that legislation into one coherent set of rules.
Which for lawyers or anyone practicing or just a student, anyone with an interest, to be able to find it all in one place, how great. Because the public may not realise that at present is not possible, that you'd have to scour the statute books. And prior to it being available online, that was quite a challenging, time-consuming exercise to find each little section from a random act that might pertain to sexual offences. But that's a great example, Ray, of where the law has to try and keep step with changing knowledge and public morality and understandings of I suppose as well, the science of trauma as well, and how things can impact on people, and try and stay up to date so that it's not maybe creating further harm by having provisions that kind of have no bearing on actual reality in some cases for people,
Yes.
But maybe tell me a little bit more about how you engage with the policy making process, or you mentioned there that sometimes you might be asked to present to the Justice Committee in the Oireachtas. Are there other ways that you would like, for example, would politicians who might be working on a private member's bill ever come to you for advice or a bit of, direction maybe on how they might approach matters?
Okay, well, the way that we look at it is that we really keep within, if you like, the projects that are in our programs, or that the Attorney General has asked us to look at. So we are not that kind of advisory body. And so where we really, in a sense, demonstrate that we're independent is that we have to be able to say, look, these are the projects that we're working on, and that is what we'll stick to. So we don't engage really outside of that. But at the same time, given that we've been around for quite a long time, there are a lot of areas that we have looked at down through the years. But I suppose there's a couple of things that I'd say on that front, Jane, which would be, first of all, that kind of big picture of what projects get into a program. We consult a lot. So policymakers in government departments, politicians ask us to look at particular areas. NGOs, of course, Irish Penal Reform Trust, Legal Aid Board, all of those, FLAC, PILA, all of those bodies make submissions to us, and we take all of those on board. So we're very much interested in, and we are engaged with, if you like, policy formation in that sense. And therefore, that also then is part of what comes into us, and then also in terms of our engagement as we go through processes. So in terms of the way that we go about our work, we'll first of all publish, if you like, what amounts to almost like a literature review of an area of law. We'll identify what the law says at the moment. We'll then say, we think we've identified some issues and problems with it, and then we will publish an issues paper. They used to be called consultation papers, and the issues papers and consultation papers are really our methodology for consulting generally, and we'll set out what we think the law is, our best summary of it, and then we will say, here are some questions that we really want people to give us their views on. Are we going in the right direction? Are these the questions that really need to be asked here? Are there some questions that we've missed out on? And so that engagement is incredibly important for us, because it allows us to get that really wide picture from all of those different interested parties, often lawyers, often policymakers, when we're looking at areas like even areas like disclosure and discovery of documents in criminal trials, which looks like, oh, this is just about a kind of a process related issue around criminal procedure. But one of the most invaluable contributions we had there were from counsellors and consultants in the healthcare sector, who allowed us an insight into the recovery process for somebody who's been through trauma, and then trying to see, yes, how we could match requirements of justice and fair trial with a recovery process. And that was hugely insightful for us, and allowed us, I think, to make quite good law reform recommendations, but which were also consistent with recovery from trauma for victims of serious violent offences. So I think that's incredibly important for us. And then we will try our best to come up with those recommendations that we think are sent. After that, it's primarily, can you still hear me there?
You were just breaking up a little bit there, but we've done well so far.
Okay.
Just when you switched tack there, maybe just go back to where you were just about to talk about something else, and then it just kind of got pixelated.
Okay. So when we try and come up with final recommendations, then what we're indicating there is that, based on the evidence that we've gathered from legal professionals, but also from non-legal professionals who are incredibly knowledgeable about things like recovery and from trauma, then we make our best effort at publishing our final recommendations, and we try and include a draft piece of legislation in our final reports. After that, it is entirely a matter for the government and the Oireachtas to decide what they are going to do about that particular set of recommendations and draft legislation. Sometimes
no lobbying occurs from anyone within the Law Reform Commission, or kind of saying, a few years later, you still haven't done anything with it, lads, what's going on here?
We certainly are indirectly, I suppose, being asked about, because there are often parliamentary questions to put to relevant ministers about, here's something from the Law Reform Commission from a few years ago, what's happened to it? We don't get involved in that. But if we're asked, as we are often asked by an Oireachtas committee, to come in and talk about our work, and particularly, I suppose, in the last few years, this has become more common because, as you know, Oireachtas committees now engage in pre-legislative scrutiny. So if a government produces heads of a bill that might be related to something that we did, then we're often asked in. And then there are quite often situations where private members' bills are based on something that we would have published. So, for example, last year, there were two pieces of legislation enacted amongst a number of private members' bills that became law last year. But one was on the law of missing persons and presumption of death, and that related back to a report that we did, and we would have been involved in discussing that with the relevant Justice Committee in terms of what we said in our report and what the private members' bill said, which was closely connected with what we had recommended. And so we were able to go in and explain our thinking behind that and helping that process along. And then a second piece of legislation that was enacted last year was on consumer insurance contracts, and a kind of a mini code of reform there, again based on a report that we did back in 2015 and was picked up as a private member's bill by Pierce Doherty TD, and then it got all party support and government support, and that ended up being enacted with, I have to say as well, the benefit of detailed scrutiny by the Finance Committee of the Oireachtas, and quite a number of improvements on the draft bill that we had produced. And so we certainly participated in that by assisting, so far as we could, the Oireachtas Finance Committee on that. So we're very happy to get involved at that level and to explain our thinking if that's helpful. And we've certainly been in situations where on some of our recommendations, I think we haven't had our feet put to the fire, but we've certainly had robust discussions with Oireachtas committees where they have said, well, why did you come up with this conclusion and why not another conclusion? So that's been incredibly useful. And I think that's very important as well in terms of transparency and accountability of the Commission in terms of it is subject to Oireachtas scrutiny where they are thinking about some of the work that we've done.
But also what a fantastic resource for the Oireachtas and for politicians to have had this research done. I mean, it's not like you just come up with the draft bill after 2 weeks of work. It's a lengthy process of thinking, reading around the area, looking often at other jurisdictions. So to have a year or two or more of research gone into a topic, plus a draft bill, that is very valuable to anyone, particularly for private members' bills where people maybe are not legal experts. So to have this groundwork done is super.
Yeah, well, we hope to be useful. I mean, I think that is incredibly important. And so I think certainly that is something that we feel we really make a contribution in terms of publishing the results of our analysis. And saying this is why we're making this recommendation. So we absolutely try, as you know from your time, we absolutely try to say this is the thinking behind it. And we've tried our best to look at best practice examples from other jurisdictions and take account of constitutional and international human rights standards. And certainly in areas like commercial law, like that area of insurance contract law, we're looking to some extent at how reforms like that can be very advantageous commercially for the state, for insurance companies. If we modernize our law in a way that's comparable to other countries, then that I think can also be regarded as competitively an important matter. And equally, we would have had very much in our minds in making those recommendations on insurance contract law, consumer protection requirements as well. So we absolutely try and explain all of that and try to be useful. I think that's really part of our function.
Just to go back to the whole consultation process again, one of the things I'm personally very interested in is how people with lived experience of whatever, whether it is of being in an accident and they need to claim insurance, but they find the process so difficult and burdensome and stressful at a time already of, you know, emotional distress and injury, or as a survivor of sexual violence, or as someone who's been through the justice system as an offender and has their rights somehow breached, or the sentencing process, you know, adoption, whatever it is, that people who've lived through an experience can get to have that experience perhaps reflected, or at least maybe inform law reform or policy making. How do you reach people like that? Can they make submissions, say, to the programs for law reform, or can they make written submissions based on an issues paper, for example?
Not only can they, but they do.
Okay.
I mean, that is certainly something that enriches our analysis as well. So we absolutely get the benefit of that. And then we're also very conscious, I suppose, if I could give you maybe one example of this in an area that I know has been debated and continues to be debated. I mean, this is the area of spent convictions.
Mm-hmm.
And so that was something where we did a report again, almost 15 years ago now, I think. And one of the areas where, you know, you can do an analysis and look at, you know, what's the law in other jurisdictions. So they've done spent convictions legislation and they've said, you know, certain convictions after a certain length of time, if they're relatively minor, And if somebody has had a clean record for, let's say, 7, 8, 10 years, you can look at lots of jurisdictions and you can say, well, they have done it in all of those other countries. So like the Cranberries, why can't we do it? And so that's one way of looking at it. Just simply say, well, everybody else is doing it, so let's do it. But what we really got a huge amount of benefit from there was talking through the connections that we have, for example, in Ballymun Community Law Centre, where Frank Murphy was able to facilitate us to meet and talk directly to, not just get written submissions from, but to talk about the lived experiences of people who are trying to turn around their lives and looking for work and facing that barrier that used to be there all the time of a conviction that might be 10 years ago, 15 years ago, and they're really struggling to get a job. And so that was another part of just trying to say, yes, the kind of analysis is relevant in Ireland, and we need to reflect that in the way that we're putting together our proposals. So we certainly did that in the context of that particular report. And then after some time, it took a while, I think maybe another 7 years, for the Oireachtas to enact legislation on spent convictions. And in that time, one of the things I think that was incredibly important was that NGOs like the Penal Reform Trust made submissions to say, well, maybe the Law Reform Commission is, and I think that's the perfectly legitimate process as well, to say, we have maybe raised the issue, we have done our piece of work, but maybe it's not good enough. Maybe it doesn't go far enough. And then it is entirely a matter for groups who are going to be able to influence that policy analysis to say, okay, they did a reasonable piece of work, but we need to go further in terms of the scope of offences, in terms of the limited exclusions, more limited exclusions than the Law Reform Commission might have proposed. And that process is incredibly important as well. And that's why it's important for the Commission, in a sense, to step back sometimes and to say, okay, we've done our analysis, but you should be able to move on. And I know that that is, even with a piece of legislation like the Spent Convictions Act, there are further moves and analysis to extend that. So that debate goes on and that sails along without necessarily the Law Reform Commission being involved, but we've made some kind of a contribution by getting that on the agenda and at least getting a piece of legislation being debated and then enacted and then improved as time goes on.
Absolutely. And there's a difficulty as well, I know, in reaching the right threshold some of the time, in the sense that to get something enacted, sometimes the tendency might be to be realistic and err on the side of a more conservative approach than a really revolutionary one, let's say, because even with spent convictions legislation, I believe there was a private members bill that went far beyond what was eventually enacted, because the appetites at the day politically were rather conservative. And now they seem to be broadening out and kind of seeing that life is a whole pile more complex. And in fact, a lot of the people who we really need to give the leg up to might have 30, 40, 50 convictions. And, you know, they're so completely outside of the scheme, you know, and have to declare the convictions forevermore, and it's a massive barrier. But the point is, as you say, it's important to get it on the agenda, even sometimes, to just get people thinking and discussing an issue.
Yes.
And so, Ray, you mentioned the Attorney General there, and how sometimes you can get an Attorney General's reference on a discrete area of law that is of importance to the government. Are there other ways that you might pick up a project that wasn't in your programme for government? For example, if there's a court case and something is struck down as unconstitutional, let's say, a legal provision, and that then causes a bit of a rumpus or a lacuna in the law that needs to be filled kind of quickly. Would that ever happen, that the Law Reform Commission would down tools or hire a new researcher to work on something in an expedited kind of way?
Well, we can't if it's not in our program,
Okay.
then it really isn't possible. Occasionally, there are projects that we're working on where there are developments in the law, and we can incorporate those into the project, but not really. But what we certainly do is there have been times when matters are debated in courts, and the courts say this is an issue that deserves to be dealt with by the Law Reform Commission. What we do is we will certainly look at that and see, well, does that come within our current program and work activity, and if it does, we can of course address that. If not, we might bank it, and then it becomes part of the next program. But that's not entirely satisfactory, because it means that's a further bit of time down the road. But often, if there's something very urgent that needs to be addressed, then the government and the Oireachtas will move on that pretty quickly, as we know that's something that had to be done in the COVID-19 situation. So just legislation needed to be updated, and then that was done, and that obviously can be done very quickly by the Oireachtas.
One thing that I found while we're talking about COVID there that I found quite interesting was, there was so much discussion prior to the outbreak about a possible right to housing, or a right to a home, and some groups have argued for a constitutional recognition. And then there was rebuttals about rent caps or stopping evictions or anything like this, because of the constitutional protections for the right to property, which we then saw at a time of a public health crisis, that actually there weren't maybe those constitutional impediments in the first place. This maybe is outside of your scope of reference here, but have we learned anything about public policy in that regard, that, for example, sometimes things don't need to take 20 years to get action on them? The possibility is there to act if we need to. Any thoughts on that, Ray?
Thanks very much for throwing that at me. So I wouldn't have a specific view about that. This is kind of like the lawyer saying, well, I can't talk about the individual case or the client that I represented. But in general terms, I suppose, what we try and do is we engage in analysis. And often, when you go through that analysis, you run across situations where it has been argued that something might be difficult from a constitutional point of view. Well, if that is the case, that's the case. Sometimes when we look at areas, we had a big project a couple of years ago on regulatory powers for economic and financial regulators. And one of the big challenges there was that there was a question mark about how far can a regulator go in imposing a financial sanction on a regulated entity. So how far could the central bank go in imposing a big financial sanction, and there's been a big debate around this about whether, in fact, only the courts can do that, and administration of justice. And so those are the kinds of questions that we've certainly had to look at. And in looking at those, then we just make our best guess at what might be, what we think might be the correct view about that. So we published an issues paper on that in 2016. And we said, well, we think from our analysis that this is constitutionally permissible. And then we had views and submissions on that particular question. As it happened, by the time we published our report in 2018, the High Court had also taken the same view, because it was a challenge to the central bank's powers. And luckily for us, the High Court took the same view as we had taken initially in the issues paper, that this is probably okay, provided that there are certain procedural protections put in place. So there are certainly situations in which you bump up against the Constitution, and you must respect that. I think in the context of property rights, that is certainly something where I think with the current legislation that has gone through, that is based very much on emergency situations, temporary situations. I think there is a separate debate about to what extent you can do things like rent freezing in on a permanent basis, or rent control on a permanent basis. So again, I would have thought that that is a separate debate, and it isn't something that we're particularly engaged in. We're not looking at things like rent control legislation at the moment. So unless somebody wants us, asks us to examine that, then I'll have to just stay a little bit agnostic on that for the moment.
Yeah, no, that makes perfect sense. And sorry for lobbing the grenade, but I've asked lots of people about it because it was such a topic, and it was thrown up time and again, oh, the Constitution, the Constitution. But as you rightly say, really, in so many cases, the law is about arguments and trying to tease things through and say,
Yes.
it could be this, it could be that. And unless it gets to the Supreme Court, the High Court or the Supreme Court, and you get a decision, it's supposition. It's someone's, best arguments based on precedent or case law or whatever to try and figure things out.
Yes.
So Ray, you've been a wonderful guest, and it's been really great to get a perspective from you about what the Law Reform Commission does, because certainly I'm a big fan of the work there. And when I was talking to former Senator Kelleher, she mentioned, dealing with the Law Reform Commission on adult safeguarding, and it's an immense resource that can be helpful 20 years down the line when you're looking back, and even just to have the analysis of case law is so helpful for anyone going forward. Just one final question. How do you publicize things like consultation processes, or when you're formulating a new program for law reform, how do people find out about this? Is it through your website, or do you tweet things, or how?
Well, that's a very good question, Jane. I mean, for the last few years, it's been primarily through the website, and we don't have a Law Reform Commission tweet account at the moment.
Okay.
But that is certainly something that's in the pipeline. But we have some very good commissioners who are very active in that area, including Commissioner Donnacha O'Connell in NUI Galway. So he certainly makes our publications and information available that way. And we have a few people who tweet about the commission, but we certainly hope to do more of that in the near future. And I can certainly tell you that our new Director of Research, Rebecca Cohen, is very interested in that. So I think there could be some news on that front. And can I just mention one last thing then before I leave you, which is the work of the Commission on access to legislation.
Oh yes, yeah.
I just wanted to mention that because that is also an incredibly important part of our accessibility of law. So one of the things that is done through the leadership of Alma Klisman in the Commission is the publication of revised acts of legislation. So in other words, these are consolidations of legislation, the text of legislation as amended. And so Alma and her team have developed over 370 revised acts now at this stage. And these are all accessible through the electronic statute book that's hosted by the Attorney General. And so I think that's also an incredibly important part of the work that the Commission does. And they are relied on, I think, by a lot of policymakers, NGOs, find them very useful, because if it's a revised act in an area that they have an interest in, then that allows people to say, yes, this is the up-to-date position of the law in that area. And one of the recent pieces of legislation that Alma would have developed would be the Health Act 1947, as amended by the brand new pieces of legislation that have just gone through in the last couple of weeks. So again, from that point of view, I think it's quite important for people to understand, what are the powers that the guards have under the Health Act 1947 as amended, and the regulations that have been made under that legislation. So I think that's incredibly important from our point of view as well, to be doing not just the work on law reform, doing the research, making proposals for changes, but also ensuring that legislation is as accessible as possible in terms of at least being available free online on irishstatutebook.ie, so that people can actually see what the legislation actually is.
Yeah, no, it's invaluable, because otherwise there could be a provision in one random act that has very little to do with health. It could just, isn't that right? It could just be shoved in there because it needs to be done. And if
Yeah.
you're under time pressure, you know, you might miss it. So to have it all in one place and say this is the sum total of the law on this area is a great benefit to lawyers and society as a whole, I think, because there's just clarity and accessibility, like you say, and it's very, very useful and practical tool for people to have. Ray Byrne, I will let you go. You don't need to sit in your car any longer now. You can go back to your day, but thank you so much for talking to me. Thank you for the wonderful work that you and your team do there at the Law Reform Commission. It's immense work. And I had great 2 years there, and always think with fondness about the Law Reform Commission, where I cut my research teeth. But this was How to Talk Policy and Influence People. My guest was Ray Byrne, the Chief Commissioner at the Law Reform Commission. Ray, thank you so much, and stay safe and well in Wexford.
Thanks very much, Jane. Thanks for the invitation.
Take care.